to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction. But if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with the latest and cutting-edge information on US immigration law policies explained in terms you don't have to be a lawyer to understand. Today's topic is H1 CapGap law for students. We will continue the knowledge session along with the news and updates on latest immigration followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hello, Ms. Reddy. Before we get into the topic, how are you doing?
I'm good, Tony. How are you?
Very well, thank you. So, before we get into the topic and start off with the questions, do you have any latest immigration updates for this week, Ms. Reddy?
We'll start with the topic.
Right. So, Ms. Reddy, how does the CapGap occur?
So, basically, this is the story behind the initiation of the CapGap law. So, what happens is when you're filing a H1 for the first time, it comes under the cap. So there's a 65,000, well, 65 plus 20,000. So 85,000 numbers available for H1s every year. So if you've never been on a H1 before and you're filing for the first time, you would most probably come under the CapGap unless you're working for an exempt organization. So if you're coming under the CapGap, what happens is you're allowed to file your H1 6 months in advance. And you have, so just to again go back a little bit more, with the H1, we first start off with the H1B registration, which is just a simple online process whereby they collect some basic information, and based on that information, the beneficiary's name, company's name, etc., they run a lottery. Because always during the cap, even because there are only 85,000 numbers available, the number of people applying for the H1 are 4 times or 5 times the amount when compared to the numbers available. So obviously they cannot do first come first serve because all the petitions arrive on the first day, which is the first possible day to file is April 1st. So in the past, all petitions would come in on April 1st. And since they cannot accept all the petitions and they can't, all of them came in the same day, they would have a lottery of all those petitions that came in on April 1st. So they were inundated by hundreds and thousands of applications, pretty much 400,000 applications this year. So what they would do is then do a lottery system, and based on a random lottery conducted by the computer, they would randomly pick out cases so that it's fair for everyone. But you have to file the entire application. Now, since 2019, they have started a new process, which is called the H1B registration process. So there's a pre-registration for H1s. Before you file the petition, in March, you're allowed to file a simple application online. And then that application is taken by USCIS and the lottery is run based on just that simple application instead of filing the entire petition. So that happens in March. That's like a pre-registration process. And once the lottery is done, they inform us of the who's been selected in the lottery by March 20th or so, before April 1st. And as of April 1st, we're allowed to file. The start date, remember the start date, the fiscal year start date for new H1Bs every year is October. It's not January. It's the start of the fiscal year, so it's October 1st. And since this H1B registration process started as per the law, they have to file within 90 days. So if it's April, then they have to file by June. right? So you are filing your H1 in advance, either 6 months in advance or 3 months in advance, 4 months in advance, June, yeah. So what happens then is often a person may not be in status for that long. So the underlying status that the person has, if it's provided it's a change of status, of course, and the most common example used is an F1. And there are a lot of, for the H1B cap cases, there are a lot of students that apply. More students than people coming from outside the country. So these students, when they apply, the people on F1 status, they have an underlying F1 status. But that underlying F1 status may not be valid until October 1st. So often, before this law came into existence, there would be a gap in their status. So sometimes they would have to leave the country and then come back on a H1. Sometimes they would have to keep on extending their F1 until October 1st, and lose OPT or CPT or whatever work status that they have. And so that was an inconvenience, because to maintain status even after filing the H1 is not easy. So USCIS came up with this law called the CapGap law. So the CapGap law basically says that once the H1B petition is filed, what needs to be done is that the copy of the H1B petition has to be then given to the DSO, designated student officer, and then the DSO, based on the copy of the H1 and of course receipt, delivery, proof. So proof of delivery would be FedEx receipt, or could be UPS or whatever courier services you're using. You make sure you use a courier service. And based on that receipt from FedEx and acknowledgement from FedEx or UPS, they would then apply under CVIS for the CapGap. So they would change the CVIS so that your status artificially continues the way it was on the date of filing. So say as of April 1st, if you're filing on April 1st, you were on a OPT status, but your OPT card was expiring sometime in June. And you will not start your H1 until October or later, because remember we're filing 6 months in advance and the start date on the H1 is October 1st. So now with this CapGap law, you're artificially extending your OPT period until September 30th. So that is the advantage of the CapGap rule.
Right.
And that's the reason why they have, this CapGap law.
Right. That's brilliantly explained and very, very much in depth. And I hope our audience understood what the CapGap law is. Now, how does a student covered under the CapGap extension obtain proof of continuing status?
Right. So the student, all they need is an updated I-20 from the DSO. So the I-20 is the only document that is needed, and that's the only document to show proof of continuing status. So basically, as I said earlier, the student should go to their DSO with evidence of a timely filed H1. So that could be, as I said, and remember, it should be a request for change of status. So it cannot be a request for consular processing, which means that in the H1B petition, you should request that you want to change status from F1 to H1. So if there is a proof of change of status, which will, be in the form, then the copy of such a petition plus a FedEx, UPS, USPS certified mail receipt, whatever, showing delivery of the package, then the student's DSO will issue an interim CapGap I-20 showing, an extension. So the extension is given first in the interim because there's no receipt until June 1st. And then, it takes a month or so, or sometimes even less if it's premium processing, about a week. If they have premium processing for CapGap cases, most often they don't. But if they do, then, it's a week or it could be up to a month. So once a receipt is received, then they'll enter it, the DSO will enter it into the CVIS record, and your CapGap will be extended. So whatever your status was as of the date of filing the H1, it will be extended until September 30th. So that's pretty much the CVIS record is something that's very important, because if the CVIS record is not updated, then as of the expiry of your, say the example we're using is the OPT. as of the expiry of your EAD or OPT card, your CVIS will be cancelled and you will fall out of status. So it's very important that they enter that information into CVIS. So it's a two-step process, enter it into CVIS, and then also issue a new I-20. So that is your proof that you're in valid CapGap status.
Right. Right. And what happens when the H-1B petition gets denied, Ms. Reddy?
Right. So you are on this CapGap status. You are issued the updated I-20. But if your H-1B Cap petition, because there's no guarantee of approval, it could get denied. It could get rejected because you didn't file it properly, and the time period to file it is over. It could be withdrawn by the employer because the employer has changed their minds and they don't have a job anymore, or whatever the reason might be. Or it could be approved and then revoked by USCIS. So if any of those happen, then the student will have a grace period of 60 days from the date of the notification of the withdrawal or revocation or denial, whatever it might be. They have 60 days to depart the US. So that, of course, the 60 days period does not apply to an F1 whose accompanying change of status request is denied due to a status violation or a misrepresentation or fraud. You don't have the grace period of 60 days in that case because you are not without fault. But in general, most petitions are non-fraudulent. So in such cases, that CapGap 60 days period is available, and during that period, then you could either file for again an extension of your F1, or you could transfer schools and apply for a new program, or you could file a change of status to some other status. Say if you have a spouse who's on H1, you could change to a H4 dependent status. So that is the 60 days grace period that comes into play. So that's what happens. So it's not the end of the world. You still have that 60 days to recover and take whatever steps are needed so that you don't fall out of status.
Right. So, Ms. Reddy, my next question is, is STEM OPT extension allowed during the CapGap period?
Yeah, so any student who receives STEM OPT, so STEM is science, technology, engineering, and mathematics. Anybody who's doing those degrees are entitled to a 24-month extension of their OPT. So otherwise, everybody else gets an OPT only for 12 months. But if you belong to one of those fields, you get a further extension of OPT for 24 months. So altogether, you would then you could stay on OPT for 3 years. So such a student who's eligible for a CapGap extension as well, post completion of their OPT employment, they may apply for a STEM OPT extension during the CapGap extension period. So even though they filed a H1, say they also want to file for the STEM OPT just to be safe, because they don't know if the H1 will get approved or not, they can do so. However, students cannot apply for a STEM OPT extension once the CapGap extension period is terminated. And we've discussed how it can be terminated. For example, if the H1 is rejected or denied or revoked or withdrawn, then such a period could be terminated, and then they will not be eligible for the CapGap extension anymore.
Right. And how to fix the start date issues, Ms. Reddy?
So just to give you a background, generally the OPT end date is September 30th, but there has been some controversy as to what should the H1B start date be. Can it be October 1st? Or can you also put a later start date beyond October 1st? So last year, or actually the year before, we had a lot of issues with H1s because a lot of H1s were actually being filed after October 1st because of this H1B registration process, everything went out of whack. So there were 3 lotteries that were held, and the recent lottery was held this year. So in that case, it makes no sense to put a backdated start date of October 1st. So it becomes backdated. So then the start date has to be after October 1st. And then when that start date was put in the past, because the case was filed in November, say, because it was picked under the second lottery, not under the first lottery. So you had another 3 months to file your H1. So in that situation, actually H1s got denied, some of the H1s. And then there was a hue and cry about it. And, the stakeholders, companies, attorneys brought it to the attention of USCIS. And they, and there was a lawsuit basically because USCIS doesn't listen to anything unless, they're forced to. So USCIS then went back on its policy and agreed that, H1s for cap cases can have a start date of beyond October 1st. It doesn't have to be exactly October 1st. It could be November, December, January, whatever it might be, as long as you're not filing the petition more than 6 months ahead. So when this was happening, then that OPT start date, the OPT end date is then September 30th. And so what happens between September 30th and then if October 1st is not the start date, then what happens to that person's status? So because of these issues, the H1B employment, the DSO in such an instance may request a data fix in the CVIS record. So remember, because CVIS has to be updated at any cost. So they can ask the CVIS record to be updated and there can be a data fix in it whereby the OPT is then extended for the period of the start date of the H1. So that's called a data fix. So it is possible. The DSO has to request that after going to the CVIS website by contacting the CVIS help desk.
So, Ms. Reddy, we're talking about the CapGap law today, and my next question is, what happens if there is change in employment?
So, say the student is terminated or laid off by the H1B employer. If the student has been approved for their change of status to an H1B, but is laid off terminated by H1B employer before the date that they officially obtain H1B status, then the student can retrieve any unused OPT if they have an expired EAD and the student will remain in F1 status and can continue their OPT using the unexpired EAD. So basically, just to reiterate, so if you're laid off or terminated after your H1B has been approved, but before the start date on the H1, remember I said the start date is October 1st or later. So say the H1 gets approved, you file it in April, it gets approved in May. So you have a H1 approval in hand, which is going to start, say, from October 1st. But in the meantime, you lose the project or the employer had to downsize and decided to withdraw the offer of employment, then what happens to your status? So if you are on OPT, the OPT CapGap, the H1B CapGap law says that you can then pick up your EAD. If you still have an unexpired EAD, then you can continue to be on that OPT EAD. But in order to do that, there's some things that must happen. The student needs to make sure that USCIS receives a withdrawal request from the petitioner before the H1 change of status goes into effect. So say in our example, if the H1 is starting on October 1st, before October 1st, the employer needs to withdraw the H1. This will prevent USCIS from changing the student status to a H1. Because once October 1st comes, automatically the status gets changed to a H1, unless they receive a withdrawal before that. So say they don't receive that withdrawal, then there's a problem because then the person will then have to leave the country because, they're on a H1 now, but they're no longer on the H1 because, the change of status has been approved and comes into effect, but they're not working for that company anymore, so they pretty much fall out of status. So once the petition is withdrawn by the employer, the student must provide the DSO with a copy from USCIS. So once you withdraw it, USCIS will send a letter acknowledging the withdrawal. So when you get that letter, the student must inform DSO, and then DSO must then contact the CVIS help desk to request a data fix. Again, this is another data fix to prevent the student from getting terminated in this CVIS system, because otherwise, come October 1st, automatically in our example, the student will have a terminated CVIS status because they would have changed to a H1. The system will think that they changed to a H1. So, as I said, if USCIS doesn't receive that withdrawal request before October 1st, then what will happen is either the student has to leave, or the student will then need to stop working if they are on OPT, and then again file for a change of status form, an I-539 form a H1 to again an F1, and then wait for that status to get approved, and then continue their OPT based on the remaining period on their EAD. So that's the process if something changes midstream. So again, to reiterate, H1B employer has to withdraw the H1B petition prior to October 1st. The student has to find, obviously, employment appropriate to their OPT if they want to continue or get back to their OPT. If the period of OPT is expired, then which would indicate that the student was not actually utilizing the CapGap since they otherwise had valid OPT authorization, the DSO requests a data fix in CVIS. So pretty much if all these things happen, then it's possible to get back into a status by either filing a change of status or withdrawing the petition before it gets approved.
Right. So, but if a student was not in an authorized period of OPT on the eligibility date for the CapGap extension, can the student work during that, CapGap extension?
So as I said, whatever their status was at the time of the commencement of the CapGap, which means the time that the H1B petition was actually received, that will continue to remain their status. So if they were not on OPT at that time, if say they were a student going to school, they will continue to be a student going to school. They will not have the authority to work. But say as we discussed earlier, during the CapGap period, if they then become eligible to file for an OPT because their studies got over and it's within the time period to file for an OPT, then they can. And then they can work. But they cannot automatically work on CapGap. CapGap doesn't give automatic work authorization to students unless they had an unexpired EAD at the time of filing the H1B.
Right, and what about international travel, Ms. Reddy? How does it affect them? As in, can students travel outside the United States during a CapGap extension period and return in the F1 status?
So CapGap, the short answer is no, because as per regulation, a student who has an unexpired EAD who is otherwise admissible may return to the US, but in this case, the CapGap is only giving them a temporary status. So this temporary status doesn't really allow you to travel and come back on an F1. So travel outside the US could be an issue because then you cannot come back on an F1 status as such. So also the problem is that if you're filing a change of status from an F1 to a H1, and if such a person travels while the change of status is pending, if it has not yet been approved, that is, then they will lose their request for change of status. That request for change of status will be considered to be withdrawn. And then what will happen is the H1 will get approved only for consular processing, and the change of status portion of the H1 will get rejected. So there are two reasons behind it. One is, of course, any change of status case, if you travel, then your change of status request is considered to be invalid. And second is, CapGap doesn't give you actual F1 status, it's an artificial status, therefore you can't travel and come back on such a status.
Right. With that, Ms. Reddy, we come to the last question of today's topic. What happens if the H1B is still pending after October 1st?
Right, so we've discussed different scenarios. We've discussed denial, withdrawal, all that. But the more likely scenario is that your H1 doesn't get approved by the time that your CapGap gets over. They're very strict about that CapGap rule because CapGap is only valid until September 30th, 2021. So if your petition has not been approved by then you may still experience a gap in work authorization. So these individuals may physically remain in the US beyond October 1st, but they have to wait for the H1B Cap petition, and they will not be allowed to work, but they can remain under a status which is basically pending status. So they don't really have any status. What you could also do is, if your H1 has not yet been accepted for processing, what you could do is use the grace period. So remember, if your September 30th is over, then you have a grace period of 60 days, which we talked about in the beginning of the show. So that you can use that 60 days grace period to then either leave the country or apply for an I-20 transfer, meaning move to a different college, start a new program, or find some other way to work with your employer and your attorney to address your current status so that maybe you can file a change of status. So yeah, it is very hard if your H1B petition doesn't get approved, and it's likely because not always is premium processing available for
Right.
H1B cap cases. So in such instances when premium processing is not available, it can take several months for the H1 to get approved.
Right. Right. So with that, Ms. Reddy, we come to the end of this show, and we're very thankful for all the information and valuable insights that you provide for us.
Thanks, Tony. It's great to be on the show, and thanks for being a great host.
Pleasure to host you, ma'am. You're watching Sakshi TV Live. This is Thorani. Thank you.